Oh, I thought we were on. Okay.
One secondary.
Okay. Well, we're live. Good afternoon, everybody. This is a joint meeting of the Senate Education Committee and the House Education Committee. I'm chairman today instead of Representative Conlon, only because I think we first organized this one, and you're joining us. In the past meetings, we've been joining you. So I think the first thing for today's topic is the Brigham decision, its origins and its implications as we go forward. We have with us John Gray from the council. But before we get going, we should have members of the committees introduce themselves, starting over here.
Hi, Representative Casey Toop, I represent St. Albans City and Town.
Leanne Harple, I represent Albany, Craftsbury, Glover, and Greensboro.
Jana Brown, I represent the town of Richmond.
Peter Conlon, Chair of the House Education Committee. I represent 5 small towns in Addison County.
Seth Longworth from the Bennington Senate District.
Chris Taylor from Milton, Georgia.
Kate McCann from Montpelier.
Representative Beth Quimby for Caledonia 3.
And we have a big enough contingent of people here that not everybody's at the table. So we'll also pick up the people, starting with Senator Beckman over there.
Steve Heffernan, Addison County District Senator.
Ralph Hunter, Manchester.
Dave Weeks from County.
And we're on Newfane, Wyndham County.
Joshua Dobrovich, Williamstown, and Chelsea.
I'm a Shane Wyndham County.
Okay, so with that introduction, Mr. Gray, the floor is yours.
Perfect. Hi, everyone. Happy Friday. John Gray, Office of Legislative Counsel. I'm gonna see if I can get this up for you guys to see. There we go. So nice having these screens. Okay, so we're going to talk about Brigham. This is the foundational case from 1997 that has directed Vermont's efforts to construct its current education finance system. When you hear talks about equity in this space, this is what we're talking about. This is the foundational case. The thing that I do want to qualify this presentation with is that it's so very easy to speculate about what a hypothetical court might take Brigham to mean, what do words like opportunity mean and the like. I'm going to be talking about what the court says rather than what a hypothetical court might mean, which means that I'm going to be talking about a lot of text. I'm going to try to stick closely to the text, but if you do have questions about the text, we can talk about that. You may be flustered that I don't want to spitball hypothetical court decisions, but I think it's kind of the safest way to proceed with this. So just starting out with historical background, in the late 80s, Vermont passed Act 84, and this created what was known at the time as the Vermont Foundation Plan. So this is what was in place when Brigham was decided. This is what was declared unconstitutional. This foundation plan funded public education through a combination of local property taxes and state aid. So that's unlike our current system, which relies on statewide raising of funds. The way that the system works, Vermont would set 2 key figures. They would set a foundation tax rate. This was a rate the state had determined was reasonable to allow localities to raise enough funds to provide at least a minimum quality education program. And then they would also set the foundation cost, which is the amount that was needed for that minimum quality program. As you can imagine, different wealth levels in districts would produce different amounts of raised funds. So that foundation tax rate wasn't producing the same funds in each district, and you could have wild disparities between them. In some cases, a district might raise more than that foundation cost, that minimum quality program amount at the foundation rate. And in a relatively property poor district, that foundation rate might not produce sufficient funds to cover the foundation cost. So in that case, state aid was provided, and state aid would be calculated to make up the difference between the foundation cost and what the district could actually raise at that foundation tax rate. It's important to call out too that the foundation tax rate wasn't mandatory. So it's possible that in a property poor district that couldn't raise at that rate sufficient funds to cover the foundation cost, they might not even be imposing the foundation tax rate. So they could be providing even less, and the state aid would still be calculated based on the gap between the foundation tax rate and the foundation cost. So they weren't getting coverage of any gap between what they actually raised and the foundation cost. So that's Act 84. That's the Vermont Foundation Plan. I'm going to flip over to a slide to hopefully show this visually, how this could work out. So hypothetical situation, these numbers may look quite small in today's current environment, but just hypothetically here, imagine a foundation tax rate of 1%. The foundation cost is $5,000, and you have 2 school districts that want to raise $10,000 per pupil. If you look here on the left side, you'll see that at the foundation rate, a relatively poor town, so able to support $400,000 in grand list per pupil, as tax rate, that 1% figure would produce $4,000, and then state aid would kick in to get that town up to the $5,000 figure. So that would take them to the $5,000 amount, but they'd be receiving $1,000 in state aid. A relatively property rich school district at that same 1% rate, so here we're talking about a $1 million grand list, could raise the 10,000 goal outright, just at the foundation rate. So you can see on the left, there's a wide disparity in what's covered there, and state aid isn't going to make up that upper gap. So on the right, what you see is if the relatively property poor school district wanted to raise that same amount, they had to impose an additional tax of 1.25%, meaning to get the same per pupil spending, that town had to tax at 2.25%, whereas the relatively property rich district could just tax at the foundation rate of 1%. And this is sort of, you can even think of this as a happy outcome that the district was able to do this. There would be cases where towns would not have capacity to do this.
I think back to this time, and if you were a town on the left, it was actually a disincentive to have families move to your community because it meant you had to come up with more money locally.
Yeah, so it's producing, as we'll see in the course discussion, produced quite wide disparities in what districts were able to do, and maybe twisted folks' abilities to make good decision making in this space.
Yeah, so just to even add one point to what Chair Connell said, it actually was a disincentive, especially for affordable housing. Yeah, so, yeah.
So, a set of 3 different plaintiffs brought allegations challenging this education finance system. There were students, there were property owners, and there were school districts themselves. There's 3 separate sets of plaintiffs. The students alleged that they were deprived, the students in property poor school districts were deprived of their right to the same educational opportunities as students in wealthier school districts. A set of property owners alleged that they had to contribute an unjust proportion of tax dollars to fund education. I will just call out that this particular claim was not addressed in the Supreme Court's decision. I think the Supreme Court said that there was insufficient facts on the record, and in any case, they had enough to work with in the other claims. So this particular allegation was not a piece that the court ruled on. And then the third claim was from the school districts themselves, saying that, and it's quite similar to the first claim, that they were deprived of the ability to raise sufficient money to provide education opportunities equal to those in wealthier school districts, and compelled them to impose disproportionately high tax rates, just like we saw on the last slide. So the court, in trying to get at this issue, first started by characterizing the purpose of that Vermont Foundation plan, and said that even if we're to assume that the plan is working adequately to accomplish the purpose, we must confront the constitutionality of the system in light of the limited nature of its purpose. The object of the plan is not equality of educational opportunity generally, or even equality of local capacity to facilitate opportunity. So you can already see this heightened focus on opportunity, which is the big thing that we talk about in this context. It is only to equalize capacity to produce a minimally adequate education, assuming the voters can sustain the state's elected tax rate. So even the goals of this plan, the Supreme Court is already characterizing in a way, expressing concern about whether or not it's meeting constitutional standards. The court spoke to sort of 3 different pieces here: wealth, spending, and opportunity. So observing capacity of the capacity to raise funds, wealthier school districts were relatively more able than poorer districts to raise the funds necessary to support an educational program that was more than that minimally adequate program that could be supported at the foundation cost. It's also important to note, and what doesn't show up on the slide, is that not only are those wealthier school districts more able to do so, they in fact did take that opportunity to spend more. So it wasn't just simply that they had the capacity, they were engaging in that kind of decision making. Second, the court drew out the relationship between wealth and expenditures, saying the undisputed evidence amply supports plaintiff's claims that wide disparities in student expenditures exist among Vermont school districts, and that these disparities correlate generally with taxable property wealth within the districts. And then lastly, you may be thinking to yourself, we're just talking about money, but this is a case about education, educational opportunity. The record didn't develop whether funding disparities themselves resulted in unequal educational opportunities. The state itself had stipulated or conceded that the funding scheme denies children residing in comparatively properly poor school districts the same educational opportunities that are available to students residing in wealthier districts. So here the court is setting up different districts based on wealth have different capacities to raise. The evidence shows that they do in fact spend differently based on that capacity. So there's a clear link between wealth and expenditure. And while there wasn't a factual record showing what the actual explicit result of those different funding schemes were, the state has stipulated that they are in fact getting different educational opportunities in different districts. And just as a basic fact, they drew out as a point that if you had less funding, you might have less tech services or like very obvious, cuts that you wouldn't have to make if you were working in a wealthier district. So tying into all this talk about money, wealth, opportunity, the court said, while equal dollar resources do not necessarily translate equally in effect, there is no reasonable doubt that substantial funding differences significantly affect opportunities to learn. And that this is key too. Money is clearly not the only variable affecting educational opportunity, but it is one that government can effectively equalize. So in ways, the court is looking at this too as a practical question. If the state is obligated to provide this, which we'll get into next, here is one tool that the state can use to affect the levers here and ensure that students are provided equal educational opportunities. Do these disparities in educational opportunities violate Vermont law? We all know this, so not really a spoiler alert here, but in Vermont, the right to education is so integral to our constitutional form of government and its guarantees of political and civil rights that any statutory framework that infringes upon equal enjoyment of that right bears a commensurate heavy burden of justification. The state hadn't provided persuasive rationale, including the rationale of local control for those undisputed inequities. Accordingly, the court concluded that the current system, which concededly denies equal educational opportunities, is constitutionally deficient. But how did the court, what was the basis for this decision? So there's two pieces here, but first we're just going to talk about the education clause and the right to education in Vermont. So if you look at chapter 268 of the Vermont Constitution, you'll see that the state is obligated to provide a competent number of schools ought to be maintained in each town unless the General Assembly permits other provisions for the convenient instruction of youth. You may be looking at this and thinking, does that establish a fundamental right to education? So the court, to support its decision that this is the hook for a fundamental right to education in Vermont, cited to the text and structure of the Constitution. So only one governmental service, public education, has ever been accorded constitutional status in Vermont. So textually, it's considered quite important that it was recognized in this way. And also its situation within the Constitution. It was placed within the chapter of the Vermont Constitution that deals with the framework of government, and it's tied together with public virtue discussions, which there's a whole history behind this, but in essence, both the texture and the text and structure of the Constitution support this claim as a fundamental right, and then additionally look to the history of the state as well. And the history lends further support, apart from its prominence in the Constitution, the importance of education to self-government and the state's duty to ensure its proper dissemination have been enduring things in the political history of Vermont. But even if there is a fundamental right to education, who is on the hook for that? The state argued in Brigham that the primary constitutional responsibility for education rests with the towns, and that the state's only responsibility, if any, is to ameliorate inequities if they become too extreme. So the state's position was, we may have this obligation, but we have made a decision. We've passed this down to town. We've covered our obligations here. We've covered our obligations. We've passed this down to the town. And if there are incidental effects from this, that's sort of an unhappy accident of the structure. The court rejected this argument and declared that the state may delegate to local towns and cities the authority to finance and administer the schools within their borders, but it cannot abdicate the basic responsibility for education by passing it on to local governments, which are themselves creations of the state. So whatever system the state is choosing, there's nothing wrong with delegating to towns this authority to finance and administer, but the state is still on the hook, still has that basic responsibility. Does the Constitution mandate a particular method of funding? The court noted that although the state has a constitutional obligation, it's silent regarding how education is to be funded. The legislature has implemented the education clause by authorizing school districts to raise revenues through local property taxes, but neither this method nor any other is constitutionally mandated. Public education is a constitutional obligation of the state, but funding of education through locally imposed property taxes is not. And even more strongly, Vermont's Constitution nowhere states that the revenue for education must be raised locally, that the source of revenue must be property taxes, or that such revenues must be distributed unequally in conformity with local wealth. So that's just the first piece, that there is a fundamental right to education. But the second piece, and what gets us to this key language of substantially equal educational opportunities, is the Common Benefits Clause. I won't bore you with the language in the first bullet, but we can think about this as comparable to Equal Protection Clause under the US Constitution. This is kind of like an anti-discriminatory principle. For providing benefits, you need to have justifiable reasons for distinguishing between the different recipients of those benefits. Education being a fundamental right, you have to have substantial reasons for differentiating here as well. The court didn't find it necessary to establish an appropriate level of scrutiny and stated the court was simply unable to fathom a legitimate governmental purpose to justify the gross inequities in educational opportunities evident from the record. The distribution of a resource as precious as educational opportunity may not have as its determining force the mere fortuity of a child's residence. So child's place of birth or residence alone should not be determining their educational outcomes. So we've talked about, so this Common Benefits Clause is, the court is hanging this guarantee of substantially equal educational opportunities on this hook. But when we talk about this, we're talking about there's always modifiers in front of educational opportunity, right? So it's reasonably or substantially. So there's a question as to what kind of variation is permissible. And the two things we know definitively from this case are kind of at different poles. So first, the court explicitly rejected the argument that achievement of a minimally adequate education is sufficient to satisfy the Vermont Constitution. We find no authority for the proposition that discrimination in the distribution of a constitutionally mandated right, such as education, may be excused merely because a minimal level of opportunity is provided to all. So the way I think about this is, even if you set in place, you provided sufficient funds for minimally adequate education, if you allowed a lot of variation above that, and the inequities were sufficient to run up against this guarantee of equal educational opportunities, that wouldn't work. You aren't satisfied simply by providing a minimally adequate education. So clearly, just having a broad degree of variation above that is not permissible. The court also observed that absolute equality of funding isn't required as well. So absolute equality of funding is neither a necessary nor a practical requirement to satisfy the constitutional command of equal educational opportunity. Equal opportunity does not necessarily require precisely equal per capita expenditures, nor does it necessarily prohibit cities and towns from spending more on education if they choose, but it does not allow a system in which educational opportunity is necessarily a function of district wealth. So those are the kind of the two poles there where the court has taken a stance on what kind of variation is permissible. Brigham's holding, the court held that the current system, the then current system for funding public education in Vermont, with its substantial dependence on local property taxes and resultant wide disparities in revenues available to local school districts, deprives children of an equal educational opportunity in violation of the Vermont Constitution. Children who live in property-poor districts and children who live in property-rich districts should be afforded a substantially equal educational opportunity to have access to similar educational revenues. To fulfill its constitutional obligation, the state must ensure substantial quality of educational opportunity throughout Vermont. So again, child's place of residence should not be determinative of the kind of educational opportunities that they are afforded. The last piece I wanted to leave here, just since we're sticking to the text, what are, kind of one theme you've seen throughout this is that the court is silent on a bunch of pieces, right? It doesn't say how it's meant to be raised. It doesn't say like within that band of variation where you should be. It doesn't specify the kind of educational system. So what can you guys take away from this and help guide in your policy decision making this session? So sort of key takeaways: Vermont students are constitutionally entitled to equal educational opportunities. Typically, it's got that modifier reasonably substantial. The state has the constitutional responsibility for public education. So even if the state decides on a method that sets the obligation down to towns, the state is still on the hook for whatever inequities result. That's the choice that the state made to delegate down to towns. It's still responsible for that. Discrimination and distribution of education cannot be excused merely because a minimal level of opportunity is provided to all. Financial resources affect educational opportunities, and money is one variable that the state has the ability to equalize. Absolute equality of funding is not required. No particular system education funding is mandated. You don't have to have property taxes. You don't have to have income taxes. The Constitution does not speak to this. And the specific means of discharging the state's constitutional duty to ensure substantially equal opportunities is properly left to you all. So happy to address any questions you have. There have been some cases in the years since then that have spoken to Brigham, but not in the detail, obviously, or drawing out the amount of guidance that we could get from Brigham itself. But yeah, happy to open it up to you guys.
Maybe just a little bit about how constitutional law works in Vermont. So this was a Supreme Court decision. It's, it is powerful and overriding of many other things. Some people have said, oh, we need to revisit the Brigham decision. Could you talk a little bit, what could that look like?
Sure.
What does that mean?
Yeah, so I think what people are probably getting at when they talk about that is that no precedent is forever. And courts change. So this is the law in Vermont today, but changes, conditions evolve over time. Even in Brigham itself, it recognized that the educational opportunities that the state might be required to provide in the 19th century are different from those it might be required to provide today. So changing conditions in the world can affect how Brigham is meant to be understood, and then the changing fact set can make a big difference too. So the recent cases, Vitale and Boyd, were brought with not great fact sets, is what I would say. And so we haven't gotten very responsive or especially helpful guidance from the Vermont Supreme Court on how Brigham might be interpreted today. We don't know what the court would do today, but what we do know, and I think we can take away from Vitale, for example, is Vitale is a case that addresses whether towns are essentially required to provide tuition. Students had brought a claim saying, that the ability of different districts to provide tuitioning, and they weren't afforded the same right, deprived them of the same educational opportunities the students in tuitioning districts had. And what the Supreme Court said there is that tuitioning was just a means of achieving educational opportunity. But it wasn't educational opportunity itself. So the court still isn't prescribing particular means of achieving this, but it has taken some position on the flexibility that the state has afforded. So I guess what I would say is just factual conditions change, the composition of the court itself changes, how it might rule. And then even the ways that we think about, maybe it's helpful to point out how other states have approached education finance. So for instance, in New Jersey or some other states, the way that their education finance systems have developed have been in sort of quite regular interaction with the courts. Basically, they're ongoing cases and they're continually getting input from the courts on how the education finance system would develop. We've been sort of, I don't know, blessed is the right word, but you had Brigham, and this system has been working for some time. At least we haven't had a case brought that shows that it's not working under Brigham. And I think that you can imagine if we switch to a new system, or we're still with the system today, and a case is brought for the Vermont Supreme Court, we might hear, I guess what I'm trying to get at is it's not necessarily a bad thing to receive guidance from the Supreme Court, and that having a dialogue with the courts is a useful thing in this space. I will pause there, and if you have, yeah,
Well, so, and by having a dialogue with the court, what that really means is having a system,
For sure.
and somebody brings a lawsuit,
for sure,
and that's what, so revisiting Brigham means somebody sues,
yes,
and the case makes it to the Supreme Court.
yes.
Doesn't that, I see what you mean in that, but then you have the court ruling how we should educate. Because in this, it's a, we want to be equal education for all. So if the state says it takes $20,000 to equal educate everybody, and every school gets that per student, you're still gonna end up with the same, and you're meeting the required education from English to art to whatever we're saying. But then the towns that have better money just get to do it, that will end up doing a little better because they have more money. I don't see how we're gonna get away. Everybody still has the same equal education. It just is like, I get a Chevy, they get a Cadillac.
Sure. So,
And is there gonna be an argument with that?
so there would be under Brigham as it sits today, which is about equalizing capacity. So the current system raises funds statewide, right? So the idea is that town school district in relatively poor area versus school district in relatively wealthier area is facing different rates because the funds are being raised statewide. So I think Vermont is already addressing this exact concern, and if you're identifying that the courts could go differently from that, they could. I can't predict what they would do. I would guess not, based on the fact that this is a foundational case, but they can, the Vermont Supreme Court can have its position. But I think the way that we've engaged in decision-making up to this point, and all of the thinking up to this point has been about maintaining the equity focus of the system. And that's kind of the key way that I think about Brigham informing the policy choices this session is how can we keep equity front of the mind as any changes are made? And equity not just in the opportunities that you're talking about, but in capacity to produce those, because that's what the Brigham Court was getting at. They were addressing a situation where exactly folks were having different cars.
And it's, I put out to both of our committees that I don't see how we're gonna change that, because, I can afford the Chevy, you can afford the Cadillac, so you're gonna make sure you have the Cadillac, and I would like the Cadillac, but I can't afford it, but I'm getting the same transportation, if you will, to get to the end goal. And there's always gonna be that disparity. And it's just how we address it as the state is saying, is your child being educated? And if the answer is yes, then, well, it's not as good. I'm going to tell you they got more money.
So the happy thing I think you're identifying is that you guys have the responsibility for that. And it is a responsibility to address that ability to produce those outcomes. And I will, I don't want to spitball ideas here, but there are ways to do this. It's not, there are suggestions out there as to how you can equalize capacity, and the current system does many things to do that. That's part of why we have what people describe as a quite complicated system. With each equity refinement comes added complexity to the system. But even in the proposal that we heard last week, there's maybe not a fully fleshed out, but there's a piece that spoke to trying to ensure that any amount beyond the base amount would equalize capacity above that to raise funds. So it's front of everyone's mind is what I would say.
Questions around?
Question. So Act 60, and then the Brigham decision, and then Act 68 came after that. Is there any way that we can find out what Act 60 did that it had to be changed so that we don't go down that road again?
So there are ways to, I've actually started doing this just because in looking at the current proposals, there are some similarities to Act 60, which was the response to Brigham. So Act 60 is what implemented the current system, and there have been tweaks since then. So I think it's certainly useful for me, maybe less useful for you guys, just to kind of backtrack through the tweaks that were made. Obviously, the weights have evolved somewhat since then. You guys have had empirical studies to support that. So there have been refinements, but I think this in part goes to Rep. Conlon's, earlier question. We haven't, had a big case like Brigham again since then. So the way that I think we've approached this is we're making it, and then trying to make enhancements that address those concerns when they arise. And then maybe this is like obvious to everyone here, but the reason that this is such a live question today, as I understand it, is the effect on people's education property tax bills, not equity concerns. So equity concerns will guide the discussion, but it's not, we haven't confronted some foundation plan type hypothetical like we were talking about on slide 2 that is leading us to try to reform the system today. The reason this is so live is less related to equity.
Yes.
Just to follow up on Vitale that you talked about. I think you said previously that part of the flaw in the argument was a failed data set. I think were they unable to substantially prove that just because there wasn't a significantly superior education if you were part of a choice community?
I think that's fair. They didn't show that the differences in educational opportunities were attributable to tuitioning. So there wasn't like a clear factual link between the claim they were making and the constitutional point about ensuring substantial equality of opportunity. And I think part of what you're getting at too is that the court left open the door that you could bring a challenge to the current system. It doesn't specify what that might be, but it's not as if the court came out and approved the existing system. So just that.
I will just, for people's historical context without a legal mind giving it to you. So Act 68, which you referred to, was a tweak to Act 60, which essentially separated its big factor was that it separated the non-homestead property tax from the homestead property tax. And then, one of the motivating factors with Act 127 that adjusted the weights was in fact a small rumble of fear that would be the next Brigham challenge, was because the weights they were arbitrary to begin with and had never been updated, that there was unequal distribution of state aid. And that was one reason why there was some impetus to move on that.
Okay. Thank you. Sure. We'll be seeing you again.
I wasn't expecting this to end so quickly, but I'm happy. Happy Friday.
Thanks, Jeff.
Thank
So
you.
with that, actually, I think we're adjourned.
We are.
Yeah.
We are
We're
adjourned.
adjourned.